that Mr. Law, at the time of the party's marriage, owned Newton Chevrolet, a dealership in Chattanooga, Tennessee, that had been founded by his grandfather in 1927. 80 years after the founding, Newton Chevrolet found itself in some diminished financial situations. Its fortunes had dimmed, principally because it had opened 2 franchises in the Chapman Road area of Chattanooga. I guess it's the Automobile Row of this town. A Mitsubishi dealership and a Oldsmobile GMC dealership. So that in 2007, Mr. Law was faced with a financial crisis. Newton Chevrolet, on the other hand, operated its business from downtown Chattanooga on 2 tracts of land, approximately 11 acres in size, that figured significantly into this case. The Chapman Road operations were 10 to 12 miles from downtown Chattanooga. In 2007, because of Mr. Law's financial circumstances, he was essentially out of cash. He had been supporting the 2 franchises out of the profits from Newton Chevrolet and out of his own pocket for a number of years. He had to borrow $1 million in order to survive until the sales of the dealerships on Chapman Road could sell. What he did in 2007 was to sell the Mitsubishi dealership and the GMC dealership to Tim Kelly, who's now the mayor of Chattanooga. That sale was for about $4.6 million. He sold what he called the Blue Sky of Newton Chevrolet for $1.4 million. And retained the real estate that Newton Chevrolet was located on in downtown Chattanooga. The proceeds from the sale to Tim Kelly were represented by real estate on which those franchises were located, car inventory, whatever else went along with the businesses themselves. He also sold separately to the Watson family, who owned the Mountain View Ford dealership, the Chevrolet dealership, and sold that for $1.5 million. The sale to Tim Kelly, the proceeds were deposited in an account that he had in Memphis at an outfit called Gerber Taylor. I incorrectly stated in my brief, as pointed out to me by the appellee, that the proceeds from the sale to the Watson family of about $1.4 million or $1.5 million were deposited in his Fidelity Investments account. I don't think that's particularly significant. In fact, it sort of bolsters my theory of the case, in that what he sold to the Watsons was clearly separate property. He had owned the Chevrolet dealership prior to the marriage. It was listed on the prenuptial agreement. There was never any finding that it had been transmuted. And when he sold the Newton Chevrolet dealership, the money that he got from it went into a separate account that we claim to be the Fidelity's investment account. At the time of the trial, the court found, and we haven't appealed, the issue that the Gerber Taylor account was marital property. So going back to 2007, Mr. Law retired. And he and Ms. Law lived on what he had deposited in the Gerber Taylor account until the time of trial. And by the time the case got to trial, the Gerber Taylor account had diminished to about $1.5 million. So he testified that other than 24 months of rental money that he got from the Watson family for the property downtown where the dealership was located, the Newton Chevrolet dealership was located, principally lived on capital. And the significant part of the real estate is this. He sold the real estate in downtown Chattanooga starting in 2016, about a year and a half before the divorce was filed. And over a period of about 2 years, garnered $8.6 million that he deposited into the Fidelity Investment account. The trial court found that this $8.6 million that he deposited in the Fidelity account was his separate property. The court commented there might have been some commingling in the Fidelity account, but it really wasn't identified. The account had existed from the time of the marriage, and the vast quantity of the proceeds in that account of what we agreed to be about $5.2 million in that account was the proceeds from the sale of his separate property. And if commingling had occurred in a time remote to the division of the marital estate, and if the effect of the commingling were no longer evident, then the de minimis commingling that could have occurred was clearly overwhelmed by the enormous deposit of $8.6 million in that account, 5.2 of which remained at the time of the divorce. Another issue in the case is a house that was listed in the prenuptial agreement. The trial court found the prenuptial agreement to be valid and enforceable. The court also found that the house at 933 Scenic Highway had transmuted from being Mr. Law's separate property to being marital property. There is an inconsistency in the if the prenuptial agreement were found to be valid, then transmutation would not have occurred. We also claim that even if the prenuptial agreement were found not to be valid, that there was insufficient evidence to amount to a transmutation. All Miss Law did was to live in the house and keep house during the term of the marriage. She invested none of her own money in the house. She had a gardener and had a daily housekeeper during the time that she lived there. And there was nothing done to the house of significance other than to have done some bathroom work at some time. And I misspoke. That's the house at 213 West Fleetwood that I talked about. That was the marital residence that the court found to have been transmuted from being separate property to marital property. The 933 Scenic Highway property is a house that Mr. Law bought during the course of the divorce itself. His mother had passed away. She lived in a house next door to his house on Fleetwood Avenue. This Scenic Highway house was the last asset of her estate. Mr. Law made application to the court to be allowed to purchase that house for a cost of $900,000. For some reason unknown to me, I don't understand the rationale of it, the court required him to put $900,000 into a custodial account. It seems that if he bought a house, it would stand good for his having spent money on it, but nonetheless, the court required him to put $900,000 into this custodial account that was maintained during the course of the divorce. The money came from his Fidelity Investments account that had been funded by his separate property from the sale of Newton Chevrolet property. So our position is that this $900,000 is not marital property as was found by the court, but is separate property that it is easily traceable to the sale of his separate property, being the Newton Chevrolet tracts of land in downtown Chattanooga. So these two houses are assets that we contend the court has treated inconsistently with its other findings in the case. The final decree authored by the trial court devotes about 12 pages of text to a discussion about the validity of the prenuptial agreement. The court made specific findings that the prenuptial agreement was entered into freely and knowingly, that it was entered into in good faith by Mr. Law, and I suppose by Ms. Law as well, and that it was free of duress and undue influence. The prenuptial agreement was signed on May 1 in 1992. The parties got married on May 2nd, 1992. Now, there may have been some, what I would call situational pressure on Ms. Law to sign the marital dissolution, the prenuptial agreement.
Counsel, I'm sorry, let me interrupt you before you run out of time here. Make sure I understand, is it your position that if a valid prenup says this property is, in this case, husband's separate property, that it will always be that, no matter what happens after that?
Well, I would say that if Mr. Law did something overt, intentional, objective to transmute the property, certainly it can be transmuted. But I don't think.
All right. So you're not saying that, excuse me, I'm sorry, getting time short. You're not saying that it can't be transmuted. You're just saying that the proof here isn't sufficient to show transmutation?
Yes, sir, I am saying that. But I think that it may be protected from accidental transmutation by the terms of the prenuptial agreement.
All right. You have your time for rebuttal. Mr. Kovalenko for the appellee.
Again, on behalf of the appellee, the overt acts of Mr. Law in connection with this are fairly tantamount to omissions that are referenced in our briefs. With regard to the fidelity account, let's focus on that. There are actually 4 fidelity accounts. There's only one listed on the prenup, which is an exhibit to the answer and counterclaim. I think it's at page 43 of the record. But with regard to that particular document, it lists certain assets. It only lists one fidelity account. There's actually 4. The testimony in this case from Mr. Law is somewhat replete. We've cited to it numerous times, wherein he says he deposited not only these sales proceeds that Mr. Lawrence continues to conflate as being Mr. Law's sales proceeds, when in fact they were an entity's proceeds. And those were deposited into the fidelity account along with his salary checks that he earned during the marriage, which are not insignificant in connection with this. We've outlined that in our brief too. In some years, he made more than $1 million. He also deposited what were clearly marital investments into the fidelity account. He also deposited, in addition to those 2 items, a joint income tax refund of $250,000. So there continued, and those have continued between 2016 to 2018. The one more significant thing I think is an issue in this case is the identification of the asset on the prenup, which is reads as Newton Oldsmobile GMC Inc. Chattanooga, and is listed for $500,000. The interesting thing about that is listed under securities, i.e. Mr. Law would own the stock in that entity. It's curious how he could do that since it was never formed until after the marriage. And in fact, the corporation was done approximately 10 days afterwards. There's a suggestion in the appellant's brief that it takes some time for the Secretary of State to issue that certificate of charter. With all due respect to counsel, that can be done within 24 hours, if not less, if you use capital filing. But in connection with that, I will just say the securities were not in existence. You cannot own something that is not in existence. He may have contemplated placing it in existence, And he may have tried to fix it so that he tried to claim it as separate property in an event like this, but it is not separate property. It was formed after the marriage. In addition to that, there were 4 different parcels of real estate that were acquired by Mr. Law and then transferred to the entity. And one of the transfers includes a quitclaim deed from the appellee in connection with this. We submit and we contend that the GMC dealership, that is the Newton GMC dealership, is in fact marital property. The significance of that is that was sold in 2007 for an excess of $4 million, as Mr. Lawrence stated. And that was deposited, guess what? Into the Fidelity account, according to Mr. Law. And we cite to that in the record. I was asked about that twice by myself in connection with this testimony. That, again, is marital property that's also commingled with the other assets. And we say as a result of this commingling, there has been a change in the character of the property. That I would admit that Newton Inc. was a separate property security owned by him. But what we're ignoring is the end result. It's not so much what was Newton Chevrolet Inc. Where are the proceeds of these sales? Where are they? And how are they secure so that they were separate? They weren't. That's the point. They were used by Mr. Law, not only for these sales that occurred by the entities and where she deposited into the Fidelity account, as he calls it, which I shortcut to, but there are 4 different accounts that he could have put them in. And in regard to that, he also continued to put in, as I've already described, marital property with it. And he also put in his separate property. There's a suggestion here in some form, in some fashion, that somehow it is the appellee's burden to show and demonstrate to the court that where the funds are. It's not our burden. Eldridge makes that clear. Smith v. Smith makes that clear. Jones v. Jones makes that clear. All of those cases make it clear that it is incumbent, if in fact it is undisputed, and there's an admission in the briefs itself that there was commingling. If there is commingling, there is a requirement on the part of the person who's claiming that to be separate property to trace the assets. There was maybe one expert that showed up in connection with this trial who was an accountant, but all he did was speak to the income tax returns. No one did any tracing. The documents were not produced with regard to this Fidelity account prior to 2007, even though they were subpoenaed. I assume are not in existence, but in any event, it's not my burden to show that where the money was put, what monies were put in there. It is incumbent upon the person who's claiming that there was no commingling, and I kept it separate. It's incumbent upon them to trace it. And then again, this argument that, oh, by the way, there's a vast majority of funds that went in here, and we spent a considerable portion of those. Judge actually does a mathematical formula in his decree showing that the amounts that were taken out would be would leave less than what was deposited by separate property, and somehow calls it separate property. That's incorrect. You have to demonstrate, again, as even Mr. Law said, money's fungible. You don't know that it's a separate property that's spent first, and you don't know what the marital property is spent first. It's not a first in, first out, or a last in, first out. It is a demonstration that you must segregate those assets, keep them separate, even if there is minimal, if you will, commingling. And that we submit there's not. We don't think $250,000 tax refund is a minimal amount. But with regard to this particular case, so the issue is we claim there's commingling, even without regard to the GMC money that was sold. we say because GMC was formed afterwards, not in existence. You can't own an asset that's not in existence. There were no securities issued until after that charter was filed. So he can't have owned them as a securities as he disclosed on his prenuptial agreement. And there is, Mr. Law says, he doesn't even know how he financed the purchase of the 4 tracts of land. He does not even know how he repaid it. And he doesn't know how he financed the buildings that the dealership were there. That's his testimony. And he doesn't know if he paid for those with his earnings or not. He doesn't know if he paid them with separate property. Because of that testimony, it is commingled. Again, the court did not make that determination. It made it did cite Eldridge v. Eldridge, but not for that proposition. But I would suggest and submit to the court that's a fairly germane issue in this case, and one that needs to be taken a serious look at in the sense of that issue would show, if in fact it's marital property, that would show that there was definitely commingling in excess of $5 million, as opposed to the monies that have been suggested previously as being minimal amount. And again, I would submit, even if it's minimal amount, there's an obligation to show and demonstrate what monies were spent by whom and where, and what types of investments were purchased with what money. That's not been done. In connection with this case, there are, at least as far as the appellee is concerned, 3 other issues. The 3 other issues are 1, dealing with the prenup itself, and 2, dealing with alimony, and 3, an award of attorney's fees. I'd like to speak to the alimony issue first, because I have a limited amount of time. There is no question that an income and expense statement was submitted for more than $18,000 a month by Ms. Law in connection with this. In the proposed findings of fact and conclusions of law filed by the defendant in connection with this case, he took issue with approximately $6,000 some odd dollars worth of the expenses. Well, if you deduct that, you still have an $11,000 need. And we are saying in connection with our brief, if in fact Fidelity is found to be a marital account, and if it is divided equitably, there will not be a need for alimony. That would be a moot issue. If in fact this court affirms the decision of the trial court with regard to this commingling in the Fidelity account, where there is going to be a need on behalf of Ms. Law, and we're asking for an increase in that alimony based upon the proof in this case.
As it stands now, Mr. Konvalinka, if we leave it as it is, she's getting, is it 2.9 million in the division of property?
She is.
Okay.
Approximately. So, and of that is the house, which is approximately 900,000 of that amount that she had will be, if she wants to have the same lifestyle that she had, she would have to maintain. And that's part of the expense that's on the income and expense statement in connection with this. You are correct.
Would you address the house on Fleetwood?
Sure. Sure. There are, as cited by the appellant, there were 4 factors for the court to consider. Normally, there's sometimes more. I think the one that's not mentioned is the one where there's a case that we cited in which someone was paying the mortgage during the period of marriage with marital funds. At the time of the marriage, there's no evidence that there was any financing with regard to the home until the same year. Mr. Law went and borrowed $200,000 using the house as collateral, which is a mortgage on the house. And he admits that he paid that $200,000 that was due, together with interest, out of his salary check. There's no dispute that the house has been the marital home for 27 years. They raised 2 children within that home, one of whom was just Miss Law's child and Mr. Law's stepchild, but one of whom was their child. There's no dispute that Miss Law was involved. There's some suggestion by the appellant that she was not, that she was involved in the maintenance and managing the home. again, of those 4 factors, we submit that there are 3 that are prevalent with regard to that. It's not been put in their joint names, but again, with regard to the payment of the mortgage payment during the period of the marriage, would again suggest that it has been transmuted, and it's been no question has been used as a home for the 27 years. And it's no question that it's been managed and maintained. So for those reasons, we agree with the judge's determination as to the transmutation of that in connection with the decision that was made. And that's what the proof shows in connection with this. And the escrow account, I will just tell you, the escrow account is he didn't reference in his argument. The escrow account was what was set up that he talked about, the 900,000. Again, that money came out of the Fidelity account. We submit to you that Fidelity account has already been commingled and inextricably commingled, and that is marital property as well. And the judge made the right decision. He made the right decision, maybe not for the right reason, but from my view, he made the right decision based upon the use of the Fidelity account monies. In connection with the prenup, there is extensive statements in our brief with regard to the facts surrounding the prenup. There's no question that she didn't get it until the day before the wedding. And when she was on her way to the airport to travel to Charlotte to become married the next morning at 10 a.m., there's no question she never saw the prenup before that. There's no question that Mr. Law had it designed, planned, and plotted 2 weeks before that by his own attorney. There is a significant error in the record. And that error is the judge found that Ms. Law's counsel advised her not to sign. There is nothing in this record that suggests that. In fact, at page 77 of the first transcript of evidence, Ms. Law says very clearly they didn't even discuss it because she didn't say they'd have time, but they obviously only had 45 minutes according to her. And so again, that's in the record twice with regard to the final decree about the advice of counsel. Again, she did not have that advice.
Well,
thank you.
Well, let me ask you a question, though, Ms. Kamalika. I mean, her lawyer was there when she signed it.
That is no question. The lawyer that she met the week before, a guy by the name of J.L. Bailey, was there. He was there with her when the other lawyer comes in and she says, no changes. There's going to be no changes, or there's going to be no marriage. That's what the testimony has been. There's no question. She said 45 minutes. She had to fill out the exhibit that's attached to the prenup. She took her 30 minutes to do that. There is a suggestion by the judge. She had an opportunity to read it by line. Well, again, they were going to catch an airplane from Chattanooga to Cincinnati. And there's also a suggestion there's no duress. He might call it situational pressure. I would say that I'm pregnant and out of wedlock, and I'm trying to make sure my child is legal with regard to it, and I'm embarrassed about it. And you don't tell me anything about it, even though you're engaged in a confidential relationship with me. You don't tell me anything about it until the day of, when you've had it for 2 weeks. And they're criticizing her in their brief for suggesting, and the judge does too, well, why didn't you ask for it? Well, she didn't even know that she was going to have it until he asked her about it. You would think that the guy who's the more sophisticated businessman and a car dealer, knows how to strike a deal, would not have waited until the last minute unless he wanted to take advantage of that deal.
Okay.
That's what I'd submit.
Your time's expired. Thank you. We'll hear from the appellant and rebuttal.
Yes, sir. Several points I'd like to make. Number one, the argument about the Chapman Road property, the 4 parcels that were identified as having been sold, really are irrelevant to the discussion. That money went into the Gerber-Taylor account. The judge divided, it had $1.5 million in it at the time of the divorce. Whatever other proceeds went into it were spent, had $1.5 million in it at the time of the divorce, and the judge divided it. He considered it to be marital property. So all this stuff about when the GMC dealership was founded, that was sold, went into the Gerber-Taylor account. That was considered to be marital property. So all that really has no relevance. It's just a misdirection of attention in the case, because those issues are really moot. I think that commingling in and of itself was maybe a incidental statement by the judge, because he never said that transmutation had occurred. You know, it's a two-step process. The court had no problem in identifying this income tax refund, whether it's marital property or not. I don't know. Mr. Law always filed a separate tax return. It was never a joint tax return. The tax was on capital gain from, or the refund was, you know, on these capital gains that resulted from the sale of the Newton Chevrolet property. That was separate property. I don't know whether the tax refund that was deposited in that account was marital property or separate property. The judge never said that the Fidelity account had been transmuted. The loan that Mr. Convalinka referred to that was paid on the Fleetwood Road house was made after the marriage. So the proposition is this: you have a piece of separate property, the house in this situation, you borrow money on it after the marriage for whatever reason, line of credit to do whatever, and you spend that money some way and you pay it back. How does that enhance the value of the house? How does it convert the house from being separate property to marital property if you use it simply as security for a loan independent of the house itself? The purpose of the $200,000 loan was never identified.
Where did the funds come from to repay the loan? Was that identified?
Mr. Law candidly speculated that he probably paid it out of his salary. So even if it were money that paid back a loan, let's say he used the $200,000 for a marital purpose and paid the money back with marital funds. That is unrelated to transmuting the house from marital property, from separate property to marital property. I don't see the connection.
Thank you. Our course, thanks to counsel for both sides. We appreciate your oral arguments this afternoon, as well as your briefs on this. Madam Clerk, if you would please recess court till our next scheduled case.
This honorable court is in recess until 2:30 p.m.
Thank you.